you to admit gangs into your school. Supreme Court told Missouri, let gangs in. 38, okay, 46, Louisiana's thinking about out-of-state subsidies. Now, not like they didn't know, not like they didn't know. Hatfield knew. Hatfield knew about the gangs case, and he knew that he had this opportunity to go to LSU because LSU had done nothing. The state of Louisiana had done nothing to provide a legal education for blacks within the state. He knew that those out-of-state subsidies did not pass constitutional muster. He also knew that after the Supreme Court decision, gang disappeared. To this day, nobody knows what happened to gangs. But Hatfield had the courage to try. So he went to John Thornton and pt2, and you see, had no money. $500 payable upon final determination or in installment payments. Okay? It's not like he could afford to hire these attorneys, but he went and he hired them to file his lawsuit. So just a little bit about them. Again, the dates. 1914. Louisiana has had black attorneys since Reconstruction. We even had a law school, State University, where blacks could go to learn to be attorneys. Closed in 1886. But Howard University was the place where blacks typically would go to get their legal training, and then they'd come back to Louisiana. Turow, 1927. Okay? Hold that in your heads, 1927. He's admitted to the Louisiana bar. The only two black attorneys in the state. So Hatfield engages their services. Okay? Lewis Berry was admitted in 45. So from 27 to 45, there were no black attorneys admitted to the bar in Louisiana. Lewis Berry, he finished law school. He actually was asked to come back and teach at Howard's law school. But his wife didn't like Washington, D.C., so they came back to Louisiana. And when he got here, he was a professor here. And for 2 years, 72 to 74, I believe, he was dean of our law school here. I'm just recognizing who you are. Lewis Berry. Right? So he returned to Louisiana in 1947, just in time to be the lead attorney on this case. So Turow asked him, because he was located in Baton Rouge, the litigation took place in Baton Rouge, Turow asked him to join in with the law in the litigation. So he was invited as co-counsel, I guess is what I should be saying. So it says that he was admitted in August 45, he took the bar exam in 45, and he has this story about preparing for the Louisiana bar. Okay, again, he's educated in Howard, he practiced in Missouri for a little while, taught at Howard, he's now taking the Louisiana bar. Where does he get the bar materials? So his story is that Archie LeCance was also a Howard graduate, and he was very light-skinned, so he just showed up at the Tulane school, and he paid his money for the bar review, and he got his materials, but then they looked. And they said, oh wait, you went to Howard, you can't come to our bar review. They gave him his money back, but they let him keep his materials. After all, they had been touched. So LeCasse was very, very willing to share his materials with Berry, and that's how he was able to study for the state bar. So this is Hatfield's litigation, filed in Baton Rouge, because LSU is in Baton Rouge. I want to note Viola Johnson's litigation. She wanted to go to medical school. So her litigation asks for Louisiana to provide a medical school. She had to make a choice, though. Her litigation was filed. She was already enrolled in medical school in Texas, and she had to choose whether to go back to Texas to finish her second and third years, or to abandon the litigation, or to wait and see if, start all over. there's some rule about medical schools that you can transfer after your first year, but you can't transfer after your second year. So she went back to Texas and finished medical school and practiced as a doctor. So because she no longer had a demand for a medical school in Louisiana, her case was mooted. Hatfield's case, however, went forward. So on first, before we get to the Porter letter, on August 22nd, Thoreau sent a letter to the Board of Supervisors at LSU and says, this is your last chance, we're getting ready to sue. This is that courtesy letter before you file litigation. We're getting ready to sue. Are you going to let Hatfield in? They want the school to write back, no, we're not going to let him in because he's black. Great 14th Amendment, right? That's right in the face of the 14th Amendment, and that's the kind of letter they want. Taylor Porter says to the chairman of the Board of Education, or chairman of the Board of Supervisors at LSU, why don't you stay out of town for a while? You know, just don't answer any mail that you get from here. Send it to me, I'm your attorney, and just say you weren't home to answer it, and that's why it got sent to your attorney. So then the attorney gets the letter, and he writes back, and he says, oh, you're in luck. The Board of Supervisors has met. The, who else? The State Department of Education has met. LSU has met. Nobody from Southern. And we've decided that we're going to start a law school up at Southern. Okay, so we have good news for you. Remember our three choices? You can let them in, you can build an equivalent school, or you can close down your school. So they chose to build the equivalent school, and that's why Southern University is in existence. But Porter's letter also includes this hint or suggestion to Thoreau, please ask your client to leave the state. Save us this money. Okay? We'd rather pay out-of-state tuition than create this new school. Okay? So we talked about two suits. I don't know if this takes me backwards. Yeah. Oops. Okay, what am I doing? Messing up. Okay. We talked about two suits, right? The how do we do it?
Back.
Yeah, I need to go way back. Now I've lost my mouse. We talked about two suits, the medical school suit and the law school suit. And I wanted to talk about the medical school suit. Yeah, thank you. Instead of trying to do that. Thank you. Viola Johnson. Okay, we said that her suit was mooted, but her suit did stimulate a conversation. Okay, the cost of starting law school was what I think they started something like $50,000, $60,000. It wasn't a lot of money. I mean, a lot more than in my pocket right now, but not a lot of money. But can you imagine the cost of starting a medical school, buying all the equipment and all? So it started the conversation that ended up in the Southern Regional Educational Board. So there were 15 states that got together and agreed to organize the Southern Regional Educational Board and to send money to Meharry Medical College. So not only were they sending money in the form of the out-of-state subsidies for the students that were attending school there, but they were directly funding a private school with public money to avoid desegregating their public schools. Meharry College had been founded in 1876 by the Methodist Episcopal Church and was in financial difficulty in 1947 and welcomed this input of cash. 1947, Meharry had graduated 50% of all the practicing physicians in the country. So it was the place to go if you're black and wanting a medical education. Right. Charles Hatfield, Houston. We said that Two Row filed the litigation, but Hatfield's litigation was not the only litigation filed in 1946 to desegregate law schools. There were 4 cases that were filed that year, and Charles Hatfield, Houston was the mastermind behind that whole theory, that whole theme of litigation. It says he was hired by the NAACP to plan a campaign against discrimination in education and transportation. He extended that to housing, but his theory in education was if I can make it very expensive for the states, they'll abandon segregation. So he started with the graduate schools. Not only were graduate schools more expensive, and having duplicate graduate schools would be very pricey for the states, but it also was less threatening. Everybody was afraid that little children would have problems. Well, here we have adults. Most graduate students are adults, so requiring their intermixing seemed less threatening to Hatfield, and he came up with this theory. Just a little bit more about Charles Hatfield, Houston. At one point, he was the dean of the law school at Howard University, and he transformed it from a part-time night program into a fully accredited day program. So we give him credit for that. He was also the mentor for Thurgood Marshall. He had a cadre of lawyers that he mentored and groomed for civil rights litigation. And so not only did he come up with what to do, but he prepared people to do it. So there were people all over the country who had been prepared by Houston to take on this challenge to segregation. As to law schools, John Howard Whiten in South Carolina created South Carolina State College. This is it's no longer in existence, but it was a all-black law school. And Howard Whiten actually attended and graduated from that school. Herman Heman Sweat. You'll hear about him in Common Law 2, I think. The Texas State University for Negroes in Austin was created as a result of his litigation. So this is a funny story. There's this big law school at Texas State University, and they decided that 4 of the professors at the State University would teach in the afternoons at the black school, which just happened to be housed in the state capitol upstairs in the corner room. Right. It was not hard for him to show that the schools were not comparable. 60,000 books versus 1,000 books. The court, in the final case where Herman Sweat reaches the U.S. Supreme Court, he goes up twice. Once about there needs to be a school, Texas creates a school. And this school was eventually moved to Houston, where it became the Texas Southern Thurgood Marshall School. He was finally admitted into the University of Texas because these lawyers trained by Houston were able to convince the court that the schools were not comparable. You can't create a school in 2 days that's going to be equal to a school that's been around 50 or 60 years.